Hi everyone, my name is Gianna MacArthur and I'm an attorney here at Novika. Today I'm here to speak with you today about my role in the Supreme Court petition. When I first received this assignment from the partners, I was excited to join because this case is closely related to violations of the Sixth Amendment of the Constitution. Now, the Sixth Amendment of the Constitution is really important because it allows for defendants to have a fair and unbiased trial. And it's the most important things in our jury system because we would want defendants to be tried by individuals who do not have any specific biases towards them in order for them to have a fair trial. One of the most important things about an unbiased trial is that a juror decides a case based only upon information provided during trial and doesn't bring their own biases into the decision-making process. So our firm worked really hard to submit the petition after the Second Circuit's unfavorable result. Part of what we focused on was that one of the jurors was a convicted felon and was given numerous opportunities to excuse himself from the jury pool, but instead he decided to lie about his status as a felon and to smuggle himself onto the jury. Now we have to look at the reason why he did this and why he didn't excuse himself from the jury as he should have. In order for a trial to be fair, a juror must only rely upon the facts obtained during trial. If a juror decides to bring in their own biases, this interferes with a defendant receiving a fair and unbiased trial. When a potential juror fails to disclose some of these biases, this interferes with the nature of the case. There is one test, the McDonough test, which is often used in situations such as this. This looks at whether a defendant lied during jury selection, whether it was material, and whether the defendant would be entitled to a mistrial. Now, this is important because this McDonough test often has a lot of different interpretations. The purpose of this petition was to allow the Supreme Court to look at this McDonough test and to create one unified way of interpreting this test. This case is important because it has a lot of different elements, including jury tainting and different interpretations of the McDonough test.
My name is Israel Klein. I am a litigation attorney with Pardalis and Novika and part of the legal team that drafted Mr. Nix's petition to the United States Supreme Court. The Nix case is important in that it implicates a fundamental right under the Sixth Amendment to the United States Constitution, the right to a trial by an impartial jury. My work on the Nix case highlighted the issue of juror dishonesty, where a prospective juror makes a false statement resulting in that individual's selection as a juror. Juror dishonesty may arise in many different scenarios. For instance, a juror may make an intentional false statement for the purpose of securing a seat on the jury. A juror may attempt to do so to obtain an opportunity to sway the outcome of the jury. A juror may also inadvertently make a false statement regarding a material question, where the juror accidentally forgets that a certain question or set of circumstances apply. In Mr. Nix's case, one of the jurors made intentional false statements to conceal that he had been convicted of the same crimes for which Mr. Nix stood trial. It was argued in Mr. Nix's petition that this deprived Mr. Nix of the Sixth Amendment right to an impartial jury. The United States Supreme Court has articulated a standard for determining when instances of juror dishonesty vitiate juror impartiality. However, there is much confusion and uncertainty as to the application of the standard, which has resulted in disparate rulings by courts throughout the country. It is therefore important for the United States Supreme Court to review Mr. Nix's case, not only to clarify how its juror dishonesty standard is applied in this instance, but in all cases addressing this issue.
My name is Greg Nahas, and I'm counsel of record in the matter of Matthew Nix versus the United States of America, currently pending before the Supreme Court of the United States on a writ of certiorari. I know that you've heard Gianna and Israel speak to you about some elements of this case that are very relatable, such as jury taint and the road to the Supreme Court. I'm going to be speaking to you today about something that's a little bit less relatable, but very important, and that's the Hobbs Act. The Hobbs Act is a well-intentioned, but ultimately flawed piece of legislation that addresses crimes of violence. And in particular, what the Hobbs Act does is, under certain circumstances, it will apply to a particular crime, in this case robbery, more specifically attempted robbery, and it will apply Hobbs Act aggravating factors to change simple robbery or attempted robbery into Hobbs Act robbery or Hobbs Act attempted robbery in this case. And then the Hobbs Act and its related statutes acts as a sentencing accelerant. Now, what do I mean by a sentencing accelerant? I mean warp speed. If some of you remember Buck Rogers in the 25th century, if you're convicted of Hobbs Act robbery, you might be able to get his autograph. Now, am I exaggerating? A little. Matthew Nix, who was convicted of attempted Hobbs Act robbery, this flawed mechanism, was sentenced to 155 years. So am I exaggerating? A little. As I said before, we're talking about attempted Hobbs Act robbery. And Hobbs Act applies to crimes of violence. An attempted crime is an inchoate crime, meaning a crime that is not completed. However, to be convicted of an attempted Hobbs Act robbery, you must intend to commit every element of that crime. To attempt Hobbs Act robbery, you would need to intend to threaten force. What does that mean? Well, when you're dealing with statutory interpretation, every word counts. And when you're looking at just the portion of the legislation that deals with sentencing for Hobbs Act robbery, the particular statute contains 3,981 words. It reads as mellifluously as a telephone book and is as easy to follow as assembly instructions for an IKEA space shuttle. A number of people enjoy that kind of reading. Admittedly, that number is very small and perhaps fractional. So rather than plodding through the statute, which we will get back to, I'd like to talk about the statutes in a manner that was illustrated to me by the late Professor Larry Kessler, may he rest in peace, by going back to primitive society, in this case Cro-Magnon society, and their efforts at developing laws and how those laws change and develop through time. In our scenario, we're going to address a law that the chieftain of this Cro-Magnon tribe is attempting to enforce due to a rising trend in people jumping off cliffs. Now, it may seem a little bit basic for us to be talking about legislating people jumping off cliffs. In modern times, we've sent men to the moon, and there's recently been a sharp decrease in the number of people eating Tide Pods. So that, bearing that in mind, let's go back to people jumping off cliffs. So, to combat this trend, our Cro-Magnon leader legislates that no one shall jump off a cliff. Now, the next day, there's a whole line of people waiting outside who have jumped off cliffs. And it is now the Cro-Magnon chieftain's duty to assess their case. So to the first person who comes in, he says, "Why did you jump off a cliff?" He said, "Well, there was a velociraptor and I was scared." The Cro-Magnon leader says, "Velociraptors are extinct. We are Cro-Magnon. Pay attention." So he switches it to a bear. "There was a bear and I was afraid because if I stayed on the cliff, the bear would kill me. If I jumped off the cliff, I might live." Cro-Magnon leader thinks about it and realizes that's a pretty good point. So no person shall jump off a cliff unless faced with the dangerous instrumentality that threatens his life. The next person comes in. This person did not see a bear. He saw a bee. The Cro-Magnon leader says, a bee is not a dangerous instrumentality. Well, the individual says, "To me, a bee is a dangerous instrumentality. I have an allergy. If a bee stings me, I will die." The Cro-Magnon leader now has to adapt the law once again. No one shall jump off a cliff unless we already have the bear. Now you have a medical condition that transforms an otherwise non-lethal instrumentality into a potentially lethal instrumentality. Another individual comes forward. He didn't see a bear or a bee. he saw a cat. A cat. A cat is not a lethal instrumentality, but this individual, he has aleurophobia, which is a fear of cats, and it's a medical condition. He's been diagnosed as, when even thinking about cats, let alone seeing them, he gets an unreasonable sense of fear and anxiety that impacts his ability to think and rationalize. So now the caveman leader must adapt the law again. No person shall jump off a cliff unless he is afflicted by a medically diagnosed condition that impacts his ability to know or appreciate the nature of his conduct or that such conduct was wrong. The law is becoming complicated, but society grows, it continues, it progresses. The caveman has now built a law based upon all of these concrete factors. He's addressed the bear. He's addressed the bee and its medical condition. He's addressed the fear of cats and that psychological condition. He's addressed other conditions, such as the individual who created a religion based upon jumping off cliffs. He addressed the other individual who jumps off cliffs as a form of political protest for the state's infringement of his right to jump off cliffs. All of these are concrete foundational elements for this statute. But as we said, society grows, it expands, it changes, it evolves. They invent the wheel. Shortly thereafter, they realize that they have a lot of wheels lying around that are useless until someone invents the axle. So they invent fire and they burn all the wheels. In short, they've progressed from Cro-Magnon society to Neanderthal society. Now, if society as a whole grows, that means lawyers as a whole grow with society. So we now introduce a Neanderthal lawyer. And for purposes of this discussion, we will call this Neanderthal lawyer Tasso. Tasso has a client, comes to him and says, I really would like to jump off a cliff. Tasso responds, you can't jump off a cliff unless you fit into one of the recognized concrete foundational exceptions of our statute that prohibits people jumping off cliffs. If you do jump off a cliff, you will face criminal penalty. So don't jump, trip. In our hypothetical, the statute fails. Why does it fail? Because it failed to account for variable change. We have a concrete foundation that is now confronted with a subjective element, and that wasn't contemplated within the legislation. What is variable change? Well, in math, it can be very broadly defined as when testing a complex solution, you substitute a variable to hopefully simplify and test the formula. Now, many of my math geek friends are going to write me and tell me that my application of variable change is more or less correct, but almost entirely less, which is fine and true if we're talking about theoretical math, but we're talking about something that matters. And I'm now going to need a larger inbox. But in our concrete example, the variable change is the subjective element. How does that end up working? For example, major premise, the sun emits light. Second major premise, feathers are light. Conclusion, the sun emits feathers. It does not work because it did not account for variable change. So how does this relate to the Hobbs Act? Well, specifically, Hobbs Act robbery. Even more specifically, attempted Hobbs Act robbery. Hobbs Act robbery is robbery with an element of being a crime of violence. As we said before, to attempt a crime, you must intend to commit every element of that crime. For Hobbs Act robbery, the element we're talking about is the threat of force. So, looking at this statute, we must now look to what constitutes an attempt to threaten force. It means you tried to threaten force and failed. The Second Circuit Court of Appeals, which is sometimes known as the 10th Justice in deference to its most famed jurist, Learned Hand, has recognized that there could be instances where an individual can attempt to threaten force. However, the Second Circuit has said that that would involve an exercise in imagination that is impermissible. Now, in many firms, the correct response would be heard and understood, Your Honors. In this firm, the correct response would be, the hell you say? In fairness, that is not the correct response from this firm, and that is not what this firm would say. That is what I would say, which is why I'm kept in a glass box that says break only in the event of litigation or one of these videos. So let's look at two examples, one of which would involve this impermissible use of imagination, and then we'll look at another that's been addressed by the Fourth Circuit Court of Appeals. As we discussed, this is an attempted Hobbs Act robbery, which means the individual must intend every element of the crime. And we all do know individuals who have the best of intentions, but then forget to carry the two, and the entire equation collapses, just like the future career ambitions of a TikToker. Or, as Steinbeck reminds us with the Gaelic spiritual, the best laid plans of mice and men gang gaff de glay. So for our first example of impermissible use of imagination, we'll have Lenny robbing George. In Lenny's attempt to rob George, he pulls a gun, points it at himself, and says, "Give me all your money or I'll shoot myself." Lenny intended to threaten violence. However, he forgot to carry the two, and he got it all wrong. Now, is that likely? No. That is one of those impermissible uses of imagination the Second Circuit warned us about. But now let's look at another example. In this example, Carlos and his partner are going to also rob George, who is having a very bad day. Carlos is a military-trained sniper. And the plan is Carlos's partner will speak to George and let him know that he is demanding his money, or else Carlos, who is hidden nearby, is going to shoot him. Carlos is apprehended while driving around looking at the trees for potential sniper hide spots. Has Carlos committed a crime of violence? Has Carlos attempted to threaten violence? Now, the Fourth Circuit has already addressed reconnoitering as an act which constitutes an attempt. Although there is no crime of violence, Carlos was driving around looking at trees for good spots to shoot someone. If that particular act was criminalized, I would be in jail for a very long time. So what happened here? I submit to you that both Lenny and Carlos tripped off a cliff. The statute fails because the statute based in concrete elements failed to object its subjective element. The statute is unconstitutionally vague and unpredictable. It is also not applied uniformly throughout the circuits of the United States, meaning the same act can be punished in two extraordinarily different ways, depending upon the jurisdiction in which the act is committed. This analysis is also known as the substantial step inquiry. However, that leads to a conundrum. Where is the line drawn? And is that line impermissibly vague? What is the answer? We know what we'd like the answer to be, and we're asking the Supreme Court to clarify it for us. Thank you.
Hi, my name is James Novika. I am a 2L at Fordham Law and a law clerk here at Pardalis and Novika. Our firm recently handled a petition for a writ of certiorari, and I was a member of the team that handled this petition. As a member of the team, my primary role was to handle a lot of the initial research and assist as the petition was being drafted with any additional research matters that came up, as well as helping the attorneys drafting the petition with any other issues they encountered throughout the process. One of the first steps that most people usually do is begin with writing a memo outlining some of the basic issues that will be encountered. This was very exciting for me as I had only dealt with this concept in the abstract before, being a law student, but it was also very interesting because coming out of 1L, the curriculum is very focused on reading Supreme Court decisions and circuit court decisions, so it wasn't something that I was completely unfamiliar with. And I was provided with a research basis by one of the partners, Joseph Novika, to help guide me through the process. Based on the research provided to me, I refined some of the legal issues that we would approach in our petition. Once the memo was drafted, I met with some of the other members of the team that would be handling the petition, such as Greg Nahas, Gianna MacArthur, and Israel Klein, and we assessed the issues as a team and distributed some of the workload amongst each other. The plan proceeding forward based on our first meeting was for me to develop a procedural history of the case. Developing the procedural history of the case is important for a few reasons. This way, the Supreme Court can see the factual background and, where this case comes from. Additionally, the procedural history gives us a reference point as to how the previous judges have handled this case and the appealable basis. Throughout the drafting process, I helped Greg with many different issues. Some of it involved doing additional research on issues that came up that we didn't initially see. It involved briefing cases, which involves basically creating a summary of the case. And from the brief, Greg was able to implement some of the language, some of the quotes, and other aspects of the judicial opinions into the petition to strengthen our arguments. Another one of my responsibilities throughout petitioning the Supreme Court was to make sure that the client was taken care of. And what I mean by that is a petition for cert is a long process, and sometimes it may appear to clients that nothing is getting done because it involves the composition of one very long document submitted to the Supreme Court under a very strict level of scrutiny. We have to make sure that the client stays updated as frequently as possible with regular updates. I provided our client with weekly updates, speaking to her as a non-attorney and trying to simplify what we were doing as much as possible. And through these regular updates, she was able to keep her son, the individual who we are petitioning on behalf of, updated as much as possible. The updates ranged from simple calls explaining that we were continuing to research and draft and we're just overall working hard on the case, to letting her know that the petition has been filed or new research and developments have come up that we will be implementing into the petition. Overall, the client contact was a very important aspect of the case because this is a stressful time for her as a mother, and as the individual we are petitioning on behalf of is the one who has to suffer the consequences if the writ for certiorari is not granted. I think overall, what some of my biggest takeaways from this is that regular client communication is a very important aspect, and that people just want to hear that you're working hard for them and that you're going to do everything you can to help them, which is what we strive to do throughout the drafting process. And our extensive research and, the collaborative effort of reading through thousands of pages of court decisions and precedent and federal statutes, finding the best approach for the Supreme Court. As a law student, it was also very interesting and an important part of professional development to see theoretical law applied in practice. Coming out of your first year, you have mostly a theoretical understanding of everything, and it can be very difficult to see the real world connection and the consequences of some of the arguments you make and the importance of coming up with the strongest arguments possible for your client. Thank you for your time.
Hi, my name is Stacey Pablo and I'm the COO of the firm. My role in this matter was filing. So my role in filing the petition of certiorari was the filing aspect. Nerve-wracking and nail-biting until the end. First time experiencing such trauma, but all in good faith. To begin, we had to create an account for the counsel of record. Once that was validated by the court, we started filing our petition. Our petition deadline was Monday. So we received an email validating our account by Thursday. So Thursday, we submitted our petition online. We received a phone call from the Supreme Court clerk stating that they have received the hard copies and the e-filing submission. The only problem was that we had the wrong petitioner name on the petition. That created a whole ordeal that day. So later on that day, we received a phone call from the Supreme Clerk stating that we need to submit labels for the petition. We had submitted over 40 copies of hard copies of the petition to the Supreme Court. So we had to make contact with our printing house for them to prepare the labels and FedEx it overnight to them. And here is where another nerve-wracking incident happened. It was Friday afternoon. Our printing house was closing early, and we were not sure if they were able to send out the labels on Friday. The head of the printing house called us around 4:00 and they said that they could send it out overnight on Monday to be received by the Supreme Court clerk on Tuesday. We emailed the clerk stating that we have refiled our petition with a corrected name because the first petition was rejected. So they asked us to refile with the corrected petitioner's name. Once that was filed, we emailed the confirmation that we filed and we sent it over to the clerk via email. We also asked if it was okay for us to submit the labels on Thursday to be received by them on Tuesday. The only thing was it was past 4:00 and the Supreme Court has closed. So over the weekend, I was trying to find different printing companies to make sure that in case the clerk does not allow us to submit the labels by Tuesday, to have a backup plan. So our backup plan was to try to locate and get quotes from different printing companies within Washington, D.C. to serve the labels within the same day, Monday. Monday, the clerk emailed us stating that that was indeed okay for them to receive the labels by Tuesday. So Monday comes around, we receive an email from the clerk stating that it's fine that we send and FedEx overnight the labels. They will be received by him in 1 to 2 days after the screening process. Along the way, we found out that there is a screening process before anything goes to anyone's desk. It usually goes through a screening process by the U.S. Supreme Court Police Department, and that takes 1 to 2 days. Once that is done, then it's delivered to the clerk's office. Wednesday, we receive an email stating that our petition labels have been received. Our submission, e-filing submission has been received. And needless to say, our case has been docketed. What an experience in itself. It was gratifying, nerve-wracking, a learning curve, and it was a team effort. Pardalis and Novika attorneys can now check off their bucket list that we have a case in the Supreme Court of the United States of America. And I am glad and happy to be part of this amazing journey, even though it was nerve-wracking until the end. Thank you so much.